Worship, I am appearing on behalf of my colleague, my Lord DM Nath, for item number, my Lord, 18 of today's list, 2026 matter, my Lord. I'm praying for some adjournment for the day.
Item number
18, my Lord. He has some personal difficulty today, my Lord.
When do you want?
Immediately after vacation, my Lord.
Which is it, isn't it? I think we have made balance list after ensuing summer vacation.
Hello,
Please,
hello.
I'd like to mention item number 34. Can it be taken up at 2? There is a small correction, Lordship. Instead of Bozali, it should be District Borpeta. And DC Borpeta and SP Border Borpeta. Lordship, thank you.
I'd like to mention item number 38. Still hearing matter, it was listed on several occasions. And painful after listing after
Give time permits. Give time permits.
Okay, item number 32 and 33. These two cases will be argued by senior advocate K.N. Survey also. Today he has some personal inconvenience also. Also may kindly fix it immediately after the vacation.
You have taken consent?
Also, I have taken,
on 14th, can it be possible?
yes, yes.
14th, we have actually fixed many cases. All matters which are being adjourned are now on those days.
Then can it be 16th?
Entire 16th,
Yes, yes.
both sides are duly presented. On the prayer made by Sir S.K. Das, none answer for the applicant of the petitioner, sorry, appellant. The matter stands adjourned today. Next, list on 16/7/2026.
It should be in the admission column final hearing, because ultimately they are filed IA, which is right along. So the
Because of IA, it will come here. You can still take it out.
Lots of the interim order may kindly be extended till 16.
Interim order passed release has extended till the next date of listing.
All right.
May I just make a mention, we'll take it out.
May I please, your lordships, one matter, my lord, there is no bail, my lord, and listed on several occasions, my lord, but could not reach, my lord. That's why I'm paying for listing, my lord. On my lord, 13th of my lord, July or 14th of Obliged, my lord.
May I please, your lordship. But I beg to mention item number 37, lordship.
Item
37, lordship. May I pray for abbreviation?
we'll make it tomorrow, sir. Make it tomorrow, we'll take it.
My obliged one.
Item number 37, lordship. May I pray for abbreviation, lordship, immediately after motion, lordship. Today is fixed for consideration of interim order, lordship. Last 3 occasion matter did not reach.
We'll take it.
Okay.
May it please your lordships, I beg to mention item 13 of the daily list, your lordships. Your lordship, I pray that the matter be adjourned, your lordship. Senior counsel is indisposed, your lordship. Item 13. 1-3, yes.
You will fix it after the meeting. Both sides are represented, also prayer made by non-counsel in the petitioner, the answer is adjourned today. List on.
Obliged, your lordships.
I'm praying for tagging an additional affidavit that has been filed. 1934.
Twenty 26 matters in the motion, we'll take those and thereafter we come to the whole motion. Item 17, 18, 17 and 19 of that class.
Fine.
Upgraded item 17, WBC 2482/26.
Yes.
May I please proceed, my lord? The name of the father of the petitioner is, my lord,
Where is the
appears in.
opinion? Opinion page.
What's that, sir?
Twenty-nine, 126, lordship.
Yes,
9 which page?
page, my lord, 38, my lord. Page 38. 38.
But Mr.
Arrest.
R.S. Johan, Learned Counsel for the petitioner and sponsor of the respondents. Opinion at page 38, dated 29/1/2026, passed by so-and-so in case number so-and-so, SP reference number so-and-so, by which the petitioner was declared to be a foreigner, 425/1973. Notice extra copies in please call for the record. Therefore, bail is opposed by the standing counsel for the appeal in other matters. In this time, bail of rupees 5,000 to the satisfaction of superintendent of police border. Which place?
My lord, the
Page 4.
SP, my lord, Vishwanath, my lord. It is now Vishwanath.
Vishwanath Charoli.
Yeah, Vishwanath.
Vishwanath.
Item 19 of the 30, 18 to adjourn.
Obliged.
Item 19,
Mr. Sharma would be required here. Ms. Bora, you are there with the records? This is.
But yet to provide me lordship with video that has not received lordship, that letter has been received by Mr. Sharma.
Take after some time.
Lordship. Sharmada is absent today, lordship. Sharmada will not come today, lordship, because he has some difficulty, lordship. After some time, I shall obtain the letter, lordship.
Yes. That will be better. You have to pay compensation. It's not excusable. No CCTV. There's a direction from the National Human Rights Commission. And it was monitored by the Supreme Court regarding installation of CCTVs in all police stations.
CCTV footage in the petrol post or hospital? Petrol post. The PPHC is health center. The petrol post will be near hospital.
Both sides are represented.
But here, even if after within the process petrol post, no. Yeah.
Both sides are represented. Pursuant to order class 15/6/2026. Have you borrowed and government advocate has produced a copy of written instructions dated 26/2026, received from the Senior Superintendent of Police, Tamulpur, wherein the letter dated 17/6/2026 by the SDM and HO, Ms. NIZ, KAUR, DAHA, Ms. Kaur Baha, BPHC. It would be relevant to put the contents of both the letters. Hearing the next paragraph. In this case, the petitioner alleges that he was brutally assaulted within the premises of Korbala petrol post, which was denied by the police by projecting that the petitioner, while trying to escape, collided with a tree and later dashed against a bamboo grove, caused injuries to the. Next one. As there is no CCTV footage, there is no CCTV installed in the concerned police petrol post. The respondents are put to notice. This say the court is inclined to issue notice to turn over on due date after revision 16/7/2026. Requisite extra copies of the petition is served on the learned government advocate within 2 days. Next, court is inclined to put the state to notice that in the absence of CCTV installed in the police petrol post, why the allegations made in the writ petition should not be accepted. By the state should not be directed to pay compensation. just from the court may deem it an appropriate. Next one. The learned government advocate shall send a download copy of this order to the respondent number 1 and 2 in this paper of this. Next, list on 16. 7/2026. Copy of instructions for this is made a part of the. It was. We are adding one more line here. Send it forward, send copy to so and so. So it's to enable both the authorities to inform the court in writing as to how many police stations, police outposts or police patrol posts do not have CCTV installed in their premises.
Upgraded item 35 for motion. Supplementary item 35.
We'll take up in the second call. If the petitioner is not there, we'll have to approve but to dismiss it. The amendment has not been done.
Yes, Lordship. Kindly make it.
Upgraded item supplementary item 36.
Your lordships, kindly pass over the matter for time being. The conducting counsel is on his way.
Item 1 for motion.
Which page is the opinion?
Opinion starting from page 19, my lord. Page 23 is how the document that I have relied, my lord, exhibit 7 and 8, how it has been appreciated, my lord, will find at page 23, my lord.
53.
2, 3, my lord. Two documents that I have relied, my lord, and exhibited to establish my linkage with my father. Unfortunately, my lord, this too, the author has not deposed, my lord, and meaning thereby Rupajan was not complied with, my lord. Page 47 and 49 is the document, my lord.
47 and 49.
Yes, my lord. One is the DP certificate, my lord, and other is the Gauhati certificate, my lord.
They were proved,
Unfortunately, my lord,
not proved.
not proved, my lord. As many as 9 documents has been exhibited, my lord, but primarily to establish my linkage with my father. These are the 2 documents that I have relied, my lord. Unfortunately, my lord, But against my husband, my lord, there was a proceeding, my lord. Husband deposed, my lord. Then in page 36 and 37, my lord will find my name is there that I am the second wife, my lord. But that was not a part of record, my lord. So primarily exhibit 7 and 8 will be the document that I will do rely.
Yes.
My lord. I have not heard what he is submitting. my lord. My lord. My lord, I am agree to do any work whichever is assigned by me, my lord, assigned to me, my lord. Yes, that we can do. My My lord, the sorry state of affairs in this category case is that, my lord, the tribunal members, they're mostly My lord, yes, lord, I'll make an effort, my lord. That is the continuous process we have taken, but some of my friends are living Guwahati. Darshana Mitra, Rupali, Samuel, they are with me, my lord, in this type of program organized. My lord. My lord. My lord. Yes, ma'am.
My lord, can I just come in picture for a moment, my lord? Appreciating the lawyers, my lord, this gentleman has been putting his efforts, at least to my knowledge, my lord, from 2016. He has conducted more than 19 impressions of us, my lord, and he has published book like this.
Yes.
Yes, my lord. More importantly, my lord, he on his behalf, my lord, has traveled across and then how to write WS, what are the things required to put in this, how to bring family trace. This was, I, yes, unfortunately, yes, madam, we are not learning. Deeply appreciated, madam. Madam. Even the notice was, this an emotional notice to notice.
Take it up for decision.
My lord, written statement is in record, my lord, page number 74, my lord. This opinion because it was against my husband, my lord. Page, it is starting from one, my lord can come to page number 36, that will make the position very clear, my lord. Against my husband, Hormuz Ali, there was a proceeding, my lord. He has been, and then in page number 36, my lord, he has mentioned that I am his second wife, my lord. Zulekha is his second wife, my lord. And that's the reason, my lord, even though Zulekha's son won, and then thereafter, my lord, his son Abdul Wajid, Malek and Hussein. This Malek Hussein, my lord, will find in one voter list is page 44. With Hormuz, Zulekha, Abdul Majid, Malek Hussein, and Atihun Nesa, my lord. That is to connect that my husband has said I'm his second wife, and he has also mentioned the name of other children's, my lord, son Abdul Malik, and that Abdul Malik name, my lord, will find at page 44. My lord. No, my 36, my lord. 32 is a different proceeding, my lord, against one of my nephew, my lord.
So Hormuz Ali is your husband?
My husband is Hormuz Ali, and Hormuz Ali has deposed, my lord, but in the opinion, my lord, against the proceeding, against his own proceedings, my lord, he has taken my name in line number 7, my lord, line number 5, my lord. OP's another wife, Zulekha. And along with this, he has also mentioned the name of the children, my lord. Along with the children, with Zulekha and husband, my lord, will find at page 30, 40 in the voter list, my lord.
Forty is not a certified copy.
40 is not a certified copy. 41 is taken from the original, my lord, as it is exhibited, not exhibited probably, my lord. Extra. WS, my lord, I have find in page 74. This is in Assamese, my lord.
No.
In the records, my lord. Records. Then I not here to devotion.
Actually, we just wanted to produce the WS because it's not here.
70.
The 8-11, now 8-12. So that 8-7,
1 to
1
16.
to 16, 8-25, 6-18.
The position of my husband will find at page 38, my lord. Oblige me.
Item 2.
May it please your lordship.
Standing going, sir.
In this case, lordship, petitioner, while calling the LCR, petitioner was granted interim relief and LCR received lordship, but no notice of motion was issued. By the order dated 4/10/19, LCR were called.
Yes, yes. Opinion is at page 57.
Yes, lordship. Page 57, annexure 17, lordship. The contested case, lordship,
Yes.
and she adduced her evidence as DW1, her brother as DW2, and Gaubura as DW3. And exhibited some documents, lordship, page 60, Exhibit A 1966 voter list of her parents. Exhibit B, order copy of her husband declaring that he is an Indian citizen. 2005 voter list, 2010 voter list, CD, E 2018 voter list, and Exhibit F 1989 voter list, where her name appeared. Exhibit H and J are Gaubura certificate, Exhibit K, L voter identity card, Exhibit M passport, Exhibit N 1970 voter list, and Exhibit P 1997 voter list, Exhibit Q 2010 voter list, and Exhibit R Chita copy, Gaon Panchayat certificate.
You see, what we find is
Lordship.
that though in 1966, you project that the father, mother, two brothers
Yes,
were voters, out of which one is DW2.
yes.
But in that, we find that the name of father is different.
First his name written as Abdul Sattar, and against Abdul Qadir's father's name Sattar Mia, lordship.
Yes.
But against the father's name of Haliman Nasa and Mokbul Mia, Abdul Sattar, Abdul Sattar. There is a slight discrepancy in the name of her father in the said voter list, lordship. Only against Abdul Qadir, lordship. 1970 voter list, Abdul Sattar, but against his father's name, Sibat. The same name appeared in the 1966 voter list.
See the opinion at page 61, DW2. Traveler finds that in every document, the name of your father is different.
From the evidence of the documents submitted by the DW1 and DW2, Proceedi's father name is different in every document, Lordship. Proceedi in the written statement only stated that her father correct name is Abdul Sattar, and in the NRC her father name written as Sattar Mia. So only this discrepancy, Lordship, Abdul Sattar and Sattar Mia.
So after exhibit N, that is 1970 voters list, the next voter list is only of 1997.
Yes, Lordship, 1971, her father died. But in 1997 voter list, page 22, Lordship, Abdul Kader, and against his father's name, Abdul Sattar. The correct name appeared, Lordship. Thereafter, in all documents, Lordship, against his father's name, Abdul Sattar appeared. Page 42, Lordship, annexure 14. In paragraph 7, she has stated that the actual and correct name of my father, Abdul Sattar, which is written over voter list, but in NRC details, the name of my father name has written as Sattar Mia. Page 49, annexure 16. And he also stated that I, Abdul Kader, son of Abdul Sattar, alias Sattar Mia. DW2 also in paragraph 7 stated. Written statement, Lordship. Written statement, page 42.
In this case, please come to page 38.
Yes, Lordship.
38 is one Ganesh Ali. Ganesh Ali is projected as brother by the petitioner. He was declared to be an Indian. Now, in the written statement at page 42,
वो कर देना।
Oh, beta, beta.
Same law.
he
Lordship, page
gives the
30,
name
38, Lordship.
42. First is
42.
38. This 38 is Ganesh Ali. In this Ganesh Ali refers to two exhibits, which is 66 and 70, page 39, last 4-5 lines.
Yes, Lordship.
Village Balidhari.
Yes.
Balidhari, and then her parents are Abdul Sattar and Haliman Nesar. Now, if you come to page 42, paragraph 8, third name is Ganesh Ali, brother,
Yes.
page 42. Now, if you come to page 57, this is the opinion,
Yes, Lordship.
and page 59, 66 and 70 are village Balidhari.
Yes.
After that, the petitioners shifted to a different village, and this Ganesh Ali shifted to a different village.
Yes.
So from there, the track is different. Please go through the records. And if required, please also examine if we have to call for the records of this page
Danish Ali.
38,
Danish Ali.
because there is a link in that.
Of the same district, only foreigners tribunal number 3 and number 1.
No, those things, we are not interested. We are interested in whether the pleadings are same or not. Whether in this, the other
Danny
case,
Ferry has also stated
said
about
the
it, yes. So Lordship may call for the records and fix it up, Lordship. When both the records are here together, Lordship can fix it up. If we have to look into his pleadings, the records have to be here, Lordship.
yes, that's fine.
Immediately on reopening, Lordship can take up this matter.
That probably no action consisted by his
S.E. Murtaja.
test scheme because of. That was possibly With order constantly, the records of the tribunal is received, which requires further examination. Accordingly, court is inclined to notice to turn over on 29/7/2026. What steps required to be taken. That's the petitioner projects the proceeding in FT case number 1022 within bracket Roman 3 bracket 2 of 2013 as a brother who has been declared to be a foreigner by not a foreigner by the learned member from Foreigners Tribunal dash Roman 3 Kolkata, Assam. Accordingly, the court is inclined to call the records page 38 from council. This from 29.
Obliged, Lordship.
21.
Upgraded item supplementary 36.
Lordship, Mr. Pine will be coming. Leftover हो गया था सर.
Yeah, we need Mr. Datta was here. Mr. Datta, we require your presence here. The petitioner here is an, oh, so you are.
Yeah, I'm appearing with this.
Okay, then it's okay.
So Lordship, that is my instructions. Sorry, Lordship, one state is there on this. Some communication also.
Exit permit is required.
Lordship.
Exit permit is required by the FRRO.
Lordship, prior to that, whatever is necessary, that is to be done by the state government. Some documents is there, the communication of government officials are also there, Lordship. That is, IG prison has to hand over.
No. Zona, you had given on that day, that order of SOP, where is that?
Oh, Lordship,
What is the-
SOP is.
What is the citation? And perhaps that went in that citation. Sharma, once the sentence is complete, you have to take timely steps. For
Yes,
issuance of
Doctor,
the travel document, as per this considered instructions of April 2014.
Lordship, one copy, Lordship, he may be allowed to serve a copy to us, Lordship. I can take the instruction, Lordship. What is going on, Lordship? Actually, copy was not served to us, Lordship. আমার জ্ঞান নাই।
Mr. Agarwal, you saved some paper and in the meantime you complicate things for yourself.
No, we have submitted.
No, because our names also not reflected, Lordship, here in the course list, Lordship. I think
In the first
copy-
topic, someone from the Home Department appeared also on the first.
Cool.
On the first day, when some from the State Department appeared also, the first authorization is reflected.
Notice, but at the time of filing,
No, you served
No.
only to the government advocate. It's not served on them. It's okay.
Lordship. Copies are not served to us, Lordship. Our names also not shown. And
Oh, you have not served.
there is special document.
You have not served. You have served it to the government advocate and to the DSGI. She is ready with the instructions. Do not give it to her.
SPA করে না, বলি company আর portal police এ করে, party।
হ'ব পাৰে না সেইটো চাই লোৱা নহ'লে আকৌ party
PDF को दियो, hard copy আছে আপনার।
চাই party। পত্রিকার নামকরণ আছে। এনেই গভর্নমেন্টটা হয়েছে গভর্নমেন্টটা হয়তো স্পেশাল ডিপার্টমেন্ট তো স্পেশাল না গভর্নমেন্টে এনে
Notice to Mr. DK, the council for the petition. P. Sharma, Ranjit Singh, for the respondent numbers 1 and 2. And R. B. Bora, Ranjit Government Advocate, appearing for respondent number 3. Next panel.
কিন্তু কোন নাম্বার
মই টিকে দেখি নাই গৈছো, কথাই কথা বাবতি গৈছো। তোমাক কপি দিবলৈ proof দেখি। কি কৈছিলে কেছ কৰিব? Online.
In the earlier method, in similar method, your lordship has passed an order, if I may bring the law.
Have it, we first require this. Now we are not, we can't pass an order. Since the instructions are not there, as per this, the FRO has to give the, the initial travel document. And you have not even implemented the FRO. There are a few difficulties. The case of the petitioner is that she is citizen of United Republic of Tanzania for being on being convicted under section 14 of the Foreigners Act of 1946. Semicolon, rule 6 of the passport and in bracket entry into India, bracket close rules of 1950. She has been sentenced to undergo 7 months simple imprisonment with a fine of rupees 1,000 for offence under section 14 of the Foreigners Act with default stipulation. She has also been sentenced to undergo 7 months simple imprisonment with fine stipulation for offence under section 6 of the rule 6 of the passport within bracket entry into India, bracket close rules from 1950 with default stipulation of the said conviction. The said order of conviction was dated 17/1/2026, was passed in PRC 1727/2025 by the Sub-Divisional Judicial Magistrate of Sribhumi. Thus, comment is projected that on completion she was taken into custody when
17/1/2026.
7 17/1/2026. That is the order, Lordship, but prior to that, she was arrested.
That is not, there is no clarity. She was on jail all throughout.
Jail since 14/7/2025.
Prior to issuance of the order.
7/25.
Yes.
Where is that statement? We have
Page,
seen it.
page 11, madam. Page 11, it is reflected in the order.
Why don't you simplify things and give it there? Are you not expecting too much for us to read the order and then find out? What was the difficulty in telling in the,
We have put it in the list of dates also.
there you have typed 14/17. You are more intelligent than us. And we don't find any date of 14/17 in our calendar.
Typo.
We understand, but you understand our difficulty. We are not reading one file. We are reading 10-15 files a day with hundreds of pages. Unless you simplify, we won't understand what you are trying to say. You see, there is a thumb rule in reading. If in 2 minutes I cannot understand, I close the file. I must understand file whether if it is, even if it is 100 pages, we'll have to understand within 2 minutes, not more than 2 minutes to a file. If we don't understand, we close it. Then you face the difficulty. It is projected that the petitioner was taken into custody on 14/7/2025, and he is in continued judicial custody since then. So accordingly, the sentence of 7 months was completed on
14/3/2002.
that means 13/2/2025, 13/2/2025, without taking into account remissions, if any.
2026.
26. Accordingly, on completion of sentence, the petitioner should have been sent back to the country of origin. Next one. Pursuant to order passed earlier, the learned CGC has produced written instructions dated 19/6/2026. And she has also produced a copy of consolidated instructions issued by the Government of India, Ministry of Home Affairs, on what is the date?
24th April.
24/4/2014. She has submitted that the office of the what is the full form of FRRO?
Foreigners Regional Registration Office.
Foreigners Regional Registration Officer, within bracket, FRRO for short, has to issue and FR to issue the exit permit after obtaining of valid travel document from the embassy of the High Commission of the country. And the matter relating to the deportation to the country of origin, the FRRO is required to take up the matter with the Ministry of External Affairs. Next, accordingly, the learned counsel for the petitioner shall provide a copy of the rate petition with all enclosures to Mr. G. Sharma and standing counsel for the FTM border matters. Next one, the learned standing counsel for the border and FT matters shall send a downloaded copy of this order to the respondent number 3, as well as to the officer, the FRRO, Sri Bhumi,
Lordship, office is in Guwahati. That instruction that is from Guwahati, whatever I have placed, not from Sri Bhumi.
FRRO Gauhati.
Guwahati.
Okay, FRRO Gauhati. Next problem. As per the instructions dated 19/6/2026, Inspector General of Police, Government of Assam has already communicated the matter to the concerned authorities of the embassy to take steps for the deportation of the petitioner to a country of origin. Next para. In the meantime, the learned CEC also send a downloaded copy of this order to the Ministry of Home Affairs and to the Ministry of External Affairs, so that the said authorities can do the needful for issuance of emergency certificate emergency travel certificate of the exit permit. Next para. Where is that order you refer to? The
Yes, in this case, the Tanzanian embassy has already issued a travel certificate. I'm also.
the learned counsel for the petitioner submits that the United Republic of Tanzania has already issued the embassy of the concerned embassy of the United Republic of Tanzania has already issued emergency travel certificate.
There are two orders, fellows. The first one is passed a direction, and then subsequently there's another order.
No, it is, I need to order. It is, no, finally, authorized.
In the meantime, the inspector, in the meantime, on the receipt of a downloaded copy of this order, the Inspector General of Prisons, Government of Assam, shall make arrangement for enabling the petitioner for making an online application to the designated online portal of http colon slash double slash Indian INDIAN FRIO gov.in for in this regard, the government advocate shall send a downloaded copy of this order to this Inspector General of Prisons, Ms. Vora, you will send, Lordship. Inspector General of Police, sorry, Inspector General of Prisons, who is she will communicate. IG Prisons, you can do it. Okay, then she should communicate it. And so. Next paragraph. When should be listed again?
Friday,
Lordship. When should be listed again?
Lordship, immediately after vacation for
This is too long. It's already spent time.
this week, then Lordship next Friday.
Friday.
Oh,
You give copies of this also to him. Otherwise, the communications will be incomplete.
There's just one difficulty, madam. In the earlier matter also, FIRO came and your lordship passed a similar order that we have to apply before the FIRO. What happened then, madam? That to apply for FIRO, the individual needs her own mobile phone and everything. Now that person is in detention. She doesn't have any mobile phone. Later on, FIRO communicated through council that all the SP, the concerned superintendent of police, they can themselves issue the exit permit. So in the earlier matter, Manoj, what happened was that the council directed the SP, SP sent the police guard and escorted her and left her to the embassy. So that's what eventually happened in earlier matter.
Including providing a mobile communication device. Or it's required for for temporary use of the petition. Make the application. Okay. Correct. You said the mobile is required for password.
Yeah, for password. They will generate an OTP and that will be sent to the mobile phone to register to
This also. If this on the next date you close this call, Friday.
Kindly copy of the order, maybe provided.
You can just kindly go on. We are returning this next time. Produce these documents next time. The order. Give that travel document to both of them. Yeah.
Much obliged.
Authorized.
Item 3.
ঘুরাই দিলেন জাজমেন্ট কিটা ঘুরাই দিলেন কিন্তু জাজমেন্ট কিটা ঘুরাই দিলেন না আগৰ
ঠিক আছে।
On the next date, you bring another copy of this order. These two orders, others, we are recalling these two orders, you make extra copies on the next day when you come.
Lordship, item 3, we do not have the file. A copy may be served and Lordship may fix it up, Lordship. Extremely sorry for this inconvenience, Lordship.
That's okay.
Item 1, we are ready with item 1 now.
Just a minute.
This is item 3.
Yes,
Three.
item 3, we do not have the file.
Acha.
We're just requesting some accommodation. We should. My number, you can talk. I do. Number देखिए। चलिए।
This is my second round, Your Lordship. First round will have the one judgment was passed against me where I can.
We have seen that page 52 is that earlier order.
Yeah,
Pursuant to that, you have examined the
Gauhati.
Gauhati. Gauhati's statement does not help you.
Gauhati is just 59 minutes, you know.
You have seen
Lordship,
that.
we can conduct this
You have
case
seen that.
with, from the
Okay, you
LCR.
give a copy, we issue notice and then we take it up for on the admission stage.
Yes, Lordship.
55 is the estimate of the Gauhati minute and it's, that is correct. When I just.
Baba, he's not, the petitioner is not on bail, we give him bail.
Not good.
Third. A Rashid, counsel for the petitioner, so and so. Pursuant to the order passed earlier, the records of the tribunal is received, which requires examination. Accordingly, the court is inclined to issue notice returnable on 29/7/2026. a copy of the litigation, with the inclusion we served on the Journals technical for the ATM border matters within 2 days. Yeah. Prayer for bail is opposed by the Journals technical for the ATM border matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police border. Border. Response. The court directed the evidence of Gauhati to be taken, that was taken. But doesn't appear that it helps.
Lordship has fixed the date, fixed a date, Lordship.
Yes, 29/7. Give a copy. Give a copy of this.
I'll give.
Item 4.
Proceed, matter may be passed for the timing.
Item 5.
Please, legal lordship. Lordship, in this case, lordship, the improving opinion
27.
of the case, 27. In this case, lordship, we have submitted one document on voter list of 1960 in the name of the father mandor. That document was not exhibited like that. Then after my letter, only one document is the school transfer certificate, my lord. But the issue authority was not my lord, my lord examined my lord. So my lord, there is no other relating document also, my lord, in this case, my lord. So my lord, I take to lordship, my lord, to take a advantage to come, my lord, in this case, my lord.
So that is for you to apply. We can't commit that. It is for you to apply. Why you waited till today?
Otherwise, my lord, my senior is out of district today, my lord, he is in Kamakka, my lord, Gurudwar, my lord, Bhandari, my lord, today, so this, my lord, some accommodation. This is very good. Bello Tapsil. Bello Tapsil. This is a one.
Number, what is that judgment? six A,
Yes, Lordship.
you have the citation of that?
6A we have, Lordship. It will take some time to. We have the SOP, Lordship, that notice citizenship.
So that's Supreme Court judgment. Yes, please.
Yes, Lordship. Judgment absolutely. Lordship, I have the citation 2024. SC.
Got it.
Yes, Lordship.
That is, 2024 5 GLT 17. And it is, 2024 INSC 789. You got it.
Mhm. 225. Next second. Double A. No, party. 296. Still लागू दिया ना? जमीन पर ना? 2025 320 196. WPC number would have wrong. 1392.
Made by. Sir, appear sir, for the petitioner, the matter stands withdrawn today. List again on 29/7/2026. The 970.
29. Lordship, in the previous matter, we found the judgment, Lordship, which is given the copy. Taking a copy of it. Begum Jan. Begum Jan, yes, Lordship.
Begum Jan,
ZAN.
ZDN,
Yes.
Begum Jan.
It's a very recent judgment, Lordship. Begum Jan.
Time being item 4.
No, sorry, I see.
The lordship.
Yes.
My lord, here in this case, my lord, our court submission, my lord, basically, my lord, based on voter list of 1965, 1970, and voter list of 1989. In 65, lordship will find in annexer 3, page 23, my father's name, Ayavali, and mother's name Suryavanu. They are in village Up Sapa Kamal.
Just.
Then my lord, in 70, 70 voter list, my parents are similarly,
Which page is the opinion?
my lord.
Opinion is at which page?
My lord, opinion, lordship will find at page 51. My lord, my submission is that 65 and 70, my parents are voters. In 89 voter list, the proceeding is voter with his mother. Mother is voter in 1965-70. So linkage is well established by these 3 documents. Legacy and linkage both are established.
The father died or what?
My lord,
Father died?
father died. Father died, but in 89 voter list, I am voter with my mother.
Where is the written statement?
My lord, written statement, annexer 2,
Page.
is ethics. In paragraph 2, I have an allegation that the case has been referred to the proper.
Just a minute.
What is this 2008 voters list? Taramia and Joy.
Yes, Taramia, my lord, is my brother, but he was voter at that time in another village, in another neighboring village.
But father's
That-
name seems to be little different.
Ayub Ali, that, my lord, these things happen, my lord. Ayub Ali, but there has been explanation. There has been explanation in the WS and evidence also, that father's name was wrongly recorded in that voter list. My lord, the 2008 voter list is annexure 6, page 29. My lord, para 14.
In your written statement, you are not giving your date of birth.
My lord, date of birth is not yet given, but I have deposed, my lord, what is my age, my lord. In verification, I have mentioned my age. So, my lord,
Age is very deceptive.
in page 21, in verification, he has deposited I, Suraj Mia, as at about 56 years. My lord, this indicates that he was born in the year 1962. So, Lord, date of birth is it possible of this category of people, my lord, that too of 1962, my lord? Date of birth.
We can't say.
So, my lord, year of birth is mentioned. And he has also given more or less family details.
Sharma, please come to page 53.
What?
53, third last paragraph, proceedings second party's own name and his mother's name appeared in the additional voters list of 1989. Proceedings second party did not mention the reason of his endorsement name in the additional amended as he attained the lawful age to cast in year in 1983. Correct?
No.
This is the reason given. Now with this reason, the tribunal accepts that the petitioner and the mother, they have a relationship. It's a positive finding. Petitioner's own name and his mother's name appeared. So that means there is no problem with the tribunal accepting that the petitioner and the mother's name appeared in 89.
Okay.
Correct? Now, in the additional voters list, can somebody question that why in the additional list the name came?
Okay.
Can there be a question put why your name appeared in the additional list? Is this a valid question?
No.
Then now you see the age Mr. Shikhar is projecting is, we find it in cross-checking, we find that the year of birth is same, 1962.
Yes. Yes. Okay.
In the written statement, his age is 56 years. In 2018, that brings us to 1962. And then from 1989, in the voters list, he's 27 years. That also brings us to 1962.
Okay. Yes,
Correct.
I have calculated.
Yes. You check and find that in 1983, elections were in February.
Okay.
My lord. My lord, 1983 election is very disputed election, my lord.
No, whatever, but that election took place in February. So in February, one may not be eligible to vote.
Yes,
If he is just, if he is not crossed 21,
yes.
he may not come, might not be of the voting age. So 83, when we don't know. So the tribunal accepts the mother, then whether the intermediary voters list are there or not, doesn't matter.
Who were the DWs? Gaubura was a DW.
My lord, DW2 was brother and Tavura, my lord, DW3. My lord, a very elderly person, my lord, on the date of my lord, declaration, my affidavit, my lord, on the date of oath, he was 78 years. And
Gaubura.
Gavura, my lord, at page 49. My lord. Vernacular person is at page 50. Is it about 78 years? My name is Kanoram Brahma. My father's name,
But he did the damage.
my lord.
The address in the certificate does not match with his present residence. And then the certificate has the state emblem.
My lord. My lord, ignoring this certificate, my lord, his oral evidence, how oral evidence can be discarded, my lord. And even the reference and the inquiry report goes to show that my father's name is Ayavali. And I have produced my father's voter list, mother voter list of 65 and 70. And I'm voter with my mother in 89. This is a very clear and shortcut evidence how this can be discarded. Merely here and there some maybe my lord inconsistency. That happens.
89 of the 9 again. 89 of the 89 you said into this one. 1897 of Bhutan is this one. 59 south. At least 59. Software B ಮಾಡಿಸಿ software B ಮಾಡಿಸಿ G लिखिसे ताल B ಮಾಡಿसे ताल मापक D ಮಾಡಿसे ताल विनापक D ಮಾಡಿसे सारी वस्तु में तो समझ गया ना Ninety-seven, 70 total is to be same. I think this is only for clarification. This 57, 70 total is. After 1970 to 1989 lordship, there is a huge gap lordship and reference
Which she is the mother.
lordship.
Once the relationship is established, but he has given with senior counsel, which is state prime minister.
90% common.
Very. What is the name? I forgot.
Lordship.
I.
Of.
Learned counsel for the petitioner. Also, I had transfer for the scholarship. Next, pursuant to order passed today, the records of the travel is received, which requires examination. Accordingly, what is inclined to issue rule returnable copy without requiring any steps to be taken. This is the matter for hearing. In the week commencing 27/7/2026.
Depolarization.
Time being item 1.
What for the other record also? Lordship, in this case, I think not necessary document this here. Lordship, I have seen the record and after verifying the documents, Lordship, he has submitted before the tribunal. I could not find any link between the proceeding and his projected parents, Lordship. Lordship, these are the evidence, Lordship, I had. And two WS has been filed, Lordship. Lordship, first WS was filed in the year of 2015. After that, each and every day, they are taking time for reducing evidence, Lordship, but that was not filed again, Lordship, on 11/6/2018, Lordship. Another advocate filed Okalatnama on behalf of them, Lordship. And after that, again, WS has been filed, Lordship, without any prior permission to the tribunal, Lordship. And
Okay, then Mr. Kamala, you please present your case then.
Lordship,
Other than page 47 is what I have. Page 47 first, my lord. Which is Exhibit 7. It was the certificate of the Gaugura, my lord. My lord have seen that the author of the certificate did not depose, my lord. So even though, my lord, my father name is there in all the documents, Exhibit 7, my father name is there, my lord. Unfortunately, because of the mistake of the conducting bouncing, my lord. Exhibit 47, my lord. It was Exhibit 7. And then, my lord, page 49 is the certificate issued by the Gauhati secretary, my lord, whereby it has been clearly mentioned that my name, my father's name. And page 38 is the deposition of my husband, my lord.
Where is that Panchayat certificate?
Gauhati certificate will, my lord, will find at page 49, my lord, 49. That in the impugned opinion, page 23, my lord. Similarly, Exhibit 8, my lord.
Which document is that? Exhibit 7?
Exhibit 7 is Gaubura certificate.
Gauhati certificate,
Yes, my lord. 47.
page 47.
Yes, my lord.
page 32.
Gauhati certificate was given as Jalekha.
Just a moment, let him complete.
Yes, yes.
Yes.
Beside this, my lord, my deposition of my husband, page 39, type copy, my lord, will find is page 38, my lord. I have not find why the deposition of my husband is not taken into consideration in the whole impugn affidavit, my lord. I beg your pardon, my lord, impugn order, my lord. And the third part, my lord, I'm re-emphasizing page 37 against my husband. The judgment and order which my lord will find is page 36. It continues out to page 37. There in line number 7, my wife, my name is there as second wife, my lord, Julekha. Jalaka.
Yes.
And then along with my husband's, my name, name appeared, my lord, page 14. And the link,
Yes,
my lord, between
yes, page 40 is your, first voter list.
yes, my lord, at the age of 30, with my husband.
Which her father is only the Town Panchayat. Sealed it. Only exhibit 5.
As far as
Does
in the LCR, my lord, I have gone through, my lord. Here in the investigation report and the reference, my lord, probably my landed friend can apprise. I have not find in which stream and the investigation has proceeded in which stream, my lord. Even though the implicit opinion was passed it by page 24, my lord, holding that it was post 1971, my lord. But in the investigation, my lord, probably I have seen my learned friend can apprise this court, my lord, as far as stream goes, my lord, because my age as of now, my lord, as far as affidavit is coming 70, my lord. Exhibit 7 and 8, my lord, even though it was not proved, my lord, but clearly indicate that my father's name is Kajimuddin, my lord. Some land records is also there, but unfortunately, the mutation records with the siblings, that is not there, my lord. And my husband part, my lord, in the opinion, my lord, husband has mentioned I am his second wife along with children, my lord. And children name, husband name, wife name has come in single affidavit, my lord, as a voter list, my lord. My lord will find a page with the children, my lord, at page 44, my lord. This is the voter list of 2010. Hurmuz Ali, Zulaikha, Abdul Majid. This is, my lord, yes, exhibit 2010 or exhibit 2010. Exhibit 11. 11. Here, the discussion about exhibit 11 is not there most likely. Exhibit 10, certified copy of the father. Itu actually, itu arwah. Arwah. Then
Exhibit 10. 10 to whom? 2000.
Kajimuddin আছে না, Hurmuz,
2010 lawsuit. Lordship, I have marked it like that. This is deposition before tribunal.
DW2 to 39 দেখুন। DW2 husband হলো page 39.
What are the other documents linking her with her father apart from Gauhati and Gaon Panchayat?
Yeah, as far as this record goes, my lord,
There is none. And Gauhati Gaon Panchayat is not proved.
no.
Can she link her father with her brother?
No. obligation.
May please, the Lordship, item number 11. Lordship, kindly passport for tail or yes, because I am doing under Lordship. Item number 11. May kindly passport for tail or yes, because I am feeling unwell Lordship today.
So the representative of the player made by land council for the petition, the question is adjourned, this law, we will take after all.
Hello.
Read it, no part?
It's okay. Lordship, here in this case, Lordship, Zalekha Khatun, Lordship, regarding a reference part, Lordship, it was reference is post 71 reference Lordship. It was specifically mentioned in the reference Lordship. So Lordship, after that Lordship, Zalekha Khatun, he trying to establish her link with her projected father Kazimuddin Lordship, but Kazimuddin's name is not appeared, but he placed some voter list of 1966 as well as NRC documents in respect of Kudus Ali, who is the son of Kazimuddin Lordship.
Kazimuddin is the father.
Father. So he has to establish her link with Kazimuddin Lordship. But here,
Kudus Ali is the brother.
elder brother.
Project.
Elder brother, who's then reflected in the NRC as well as 1966 voter list as well as 1970 voter list Lordship. But
Yes.
but Lordship, this Kudus Ali is this Kudus Ali is become invisible after 1970 Lordship. After 1970 to 1997, 27 years of gap, 27 years of gap Lordship. Kudus Ali. Even in 1997 also Kudus Ali's name is not appearing. Some Abdul Kudus name is appeared Lordship in the 1997 voter list. And if we see the evidence part Lordship in the year of 2018 Lordship, mm, yes. So Lordship, 1970 to 1997 Lordship, that part is why there is a huge gap in between 1970 to 1997 Lordship. That reading is not there in the case of the proceeding Lordship. After that Lordship, if we consider the age Lordship in the year of 2018, while he deposed before the tribunal Lordship, her age was 62 years.
in the year of 2018. If he is 62 years, in 2018, he is sometimes born in the year of 1956.
Yes.
So she is getting her first voting right in the year of 1977, 1956 plus 21. And Lordship, if we see the deposition of the husband, Lordship, in the same year, Lordship 2018, he said in his deposition that he got married 35 years ago, Lordship. In page 39, we got married sometimes 35 years ago. If
Her age is 60 years. She's about 60 years.
is yes, Lordship. So if her marriage was solemnized 35 years ago, Lordship, that means, Lordship, she got married in the year of 1983, 2018 minus 35. Yes. So, Lordship, again in her deposition, DW1 proceeded, Lordship, she said that her elder brother Quddus Ali expired 10 years ago.
Pardon me, you are reading where?
Lordship, evidence part, evidence of husband, no, evidence of the proceeding, Lordship. In record, it is page 11, Lordship. Quddus Ali, Quddus expired sometime,
Just a moment.
10 years back.
Age,
Page 11 of the record, and in the repetition, Lordship, it is,
It's not there, brother.
it is not there.
not there. What does it say?
It said, Quddus expired 10 years back, and Alimuddin expired 11 years back. That Quddus Ali and Alimuddin both are her brother, Lordship.
Quddus expired 11 years back. And
Quddus 10 years back, Alimuddin 11 years back. So, Lordship, 2018 minus 10, that is 2008, Lordship. So, Quddus Ali is very much available up to 2008.
please come again, 1983 to
2018, he deposed in the year of 2018, Lordship.
2018 means 2008.
8 November 2018.
So 2008.
The deposition,
No, 2008, he will be alive.
yes, Lordship. Yes. So, but after 1970, Lordship, that Quddus Ali becomes invisible, Lordship. And if proceedee, Lordship, got married in the year of 1983, her name should be there along with her projected brother, as she is getting her first voting right in the year of 1977. So,
Come again.
Lordship, my earlier submission was that a husband of the proceedee said that their marriage was solemnized 35 years ago. So, Lordship, sometime in the year of 1983, 2018 minus 35. And Lordship, She is getting her first voting right in the year of 1977, as she is born in the year of 1956. So, Lordship, 1977 to 1983, there must be some document along with her elder brother, Lordship.
Did she mention about her brother Kudus Ali in the written statement?
Yes, Lordship, that is why I am saying, Lordship.
Written statement.
Yes, Lordship. Statement is not enough, Lordship. Otherwise, there must be some document in respect. uh, there must be some document along with her brother, Lordship, elder brother. So, Lordship, if this evidence goes, Lordship, only part is that voter list, Lordship. Voter list, non DB certificate, Gaon Panchayat certificate. These are the main link document, Lordship. Both of these documents are not proof, Lordship. Again, Lordship, Gaura certificate given in the name of Lordship Jalekha Begum, wife of Hormuz Ali, not as a daughter of Kazimuddin, Lordship.
She was known as the daughter of Kazimuddin.
There is another Gaura certificate, Lordship.
Took one from the husband family and one for the father family.
Yes, Lordship. Exhibit 7 is the in the name of Jalekha Khatun, daughter of late Kazimuddin, Lordship. So, Lordship, even there is a certificate, Lordship, death certificate without being proved cannot be considered, Lordship. So, Lordship, if Gaubra certificate and Gau Panchayat certificate goes, Lordship, nothing will remain, Lordship, to prove her citizenship or to establish her link with the person whose name appeared in the voter list of 1966. Okay. So, Lordship, I think, Lordship, there is nothing more to submit, Lordship. My humble submission is that there is no infirmity in the opinion passed by the learned tribunal, Lordship. So,
Record from
matter may be, opinion may not be disturbed.
But she has mentioned her brother as Kudus.
Yes, yes, in
And
WS,
her brother's name is there with her father. So that way, the link is established.
yes, Lordship, but after 1970 to 1997, Lordship, there is a huge gap, 27 years. And in evidence, what he has stated that late Kudus Ali was expired 10 years ago. So he must available in the up to the year of 2008. Okay. So there must be some document along with her elder brother, Lordship.
Before my lord peruse the LCR, my lord, may I submit only one point, my lord? My lord, my respectful prayer will be to peruse page 49 once more, my lord. Page 49. Even though it's not proof, my lord, but here there is a mention of the year, my lord. Year of marriage. Year of marriage is, even though it's not proof, my lord, 5974. No, 49 of my writ petition, my lord. The Panchayat certificate, my lord, issued by the secretary of the Gaon Panchayat, my lord, whereby my father's name, my name, my husband name is there, and he has mentioned that 5974 is the date of marriage, my lord. And thereafter, my lord, with the husband, probably, my lord, there will be another voter list, my lord, but here it is 1989. Here my age come at around age 30, my lord. So there will be 1 or 2 years here and there will be, as far as marriage goes, my lord, my husband categorically said, my lord, 35 years. Here it is only a part, my lord. I am handicapped for the purpose, my lord, in the absence of deposition of the secretary, my lord. Otherwise, I am the daughter of Kazimuddin. Certificate, two certificates, exhibit 7 and 8 clearly demonstrate that I am the daughter of Kazimuddin. And my husband has taken my name as second wife, and along with my children, my
ৰেকৰ্ডৰ পৰা পাৰিলে হয় হাজবেণ্ডে বেছি ভালকে জানিবনে ছেক্ৰেটাৰী বেছি ভালকে জানিব ইয়াৰ কথাটো ছেক্ৰেটাৰী ভালকে জানিবনে হাজবেণ্ডে ভালকে জানিব ইয়াৰ কথাটো কেতিয়া হৈছে
in the WS I have not mentioned, madam. But as far as one brother goes, against whom there is a proceeding, madam.
So, but in the evidence is something there, how many brothers know?
Somewhere mentioned lordship.
WSF 9, it is. WSF 9.
It was two WS is dear lordship.
You see, that's why we are asking.
Yes.
In the opinion, how many witnesses were examined?
In the opinion, my lord, two. Two. PW, yeah, we can. Two. Yes, we can open. I'm sorry, my lord. As far as past questions of this honorable court, my lord, page 20, how many brothers and sisters I have? One brother's name mentioned in page number 20 against whom there was a proceeding who has been declared as an Indian citizen, my lord. One of the brother, it means the language of this opinion goes, there will be a statement, but unfortunately here in the WS probably, my lord, in the page 74, unfortunately in Assamese language, my lord, I have, even though I have gone through, my lord, but that's what my learned friend is saying, that he finds somewhere that my description of my family details is there. But in the opinion, one of her brother, Abdul Salam, which my lord will find at page 32. Opinion to this number page is अपनी सब Abdul Salam reference to us. itu 32 number page ada. That is. Yeah.
This goes for remand.
No, sir.
Yes. Another goes. First of all, in the order, the opinion, impaired opinion,
No,
how many witnesses were referred to?
it is not referred, only opposite party deposed that her father,
Correct.
yes, one,
That is at page 20.
20.
Correct. Now there's no reference to any other if I am not missed something. Now please come to page 101. Please flag 101.
Yes.
You have seen this? This is
Yes.
Jaleka Khatu.
Yes.
Now please turn over to page 104. Yes. Now count the exhibits. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,
11.
12, 13,
15.
14, 15. Correct. 15 exhibits are not referred in the opinion.
Yes, okay.
Correct. Now come to 127. 127. This is Mahmood Ali, second time. Correct. Yes. Then come to 129. Kalimuddin. 3 witnesses. Correct.
Yes.
Now please come to the order sheet of 9718. 9718 order sheet.
Copy is present and wait for
And 3 affidavits with documents. Correct.
copy is present and wait to abuse evidence. Exhibit.
No. 9718.
Yes, proceed.
3 witnesses.
Before that order.
9718.
9718.
Yes, copy is present with same.
3 affidavits filed.
Yes, proceed.
Correct. With documents. Correct. 3 witnesses are there. And now, come to page 146 onwards.
One copy,
6. Last
Yes.
part.
land document.
So these are 14 exhibits, 15 exhibits, out of which exhibit 14, don't know whether how it is. This is 2, after that there is 1.
This is, I think,
Exhibit
exhibit
two.
2.
Yes, after that there is exhibit 1.
Yes.
Now see. Then all the exhibits are there. On the exhibit 14, I think it is struck off. 14, the marking of the court is not there, taboo is not there. 14 is perhaps,
Proceed. Exhibit 2, Lordship, here signature of the member is here, Lordship, and
only 14, all of this I found.
exhibit 1, here also signature is here, Lordship.
Exhibit 14,
14.
you are not getting this reason. 14 is struck off, I think, last fine.
It was
Struck off.
struck off.
If 14 is there, otherwise 15 is also marked. That means 14.
Yes, proceed.
How these are not considered?
Yes, proceed. Underground is maybe even.
So long time I never see the record first.
Yes, proceed.
Yes, the other for the petition. And so for the respondents.
Like you want to be.
By filing this petition under Article 226 of the Constitution of India. To the Assembly so and so, as I said, the opinion dated page 19. Okay, 26/11/18 passed by so and so in case number so and so, SP inquiry number so and so. Now will the petitioner was declared to be a partner of 425 to 93. In view of the nature of order proposed to be passed, who does not find any reason to burden this order with pleadings and evidence on record. It is suffice to mention that as per order dated 9/7/2018, passed by the learned tribunal, the evidence on affidavits were filed. The PCR reveals that the evidence on affidavits, respectively filed by the petitioner, Hurmuz, HURMJ, Hurmuz Ali, and Alimuddin, KALIMUDDIN, are available at page 101, 127, and 129 respectively. Next, as per the evidence on affidavit filed by the petitioner as DW1, she has exhibited 15 documents. Our the records reveal that the photocopies of the proofing original documents are available at page 146 POP. One 69. All bearing, of all except exhibit 14 bearing the signature of the learned member. It appears that our same photocopy of same document, i.e. the affidavit one on 25/6/2018, marked as exhibit 14 and exhibit 10 respectively, which are available at page 162-163 and page 166/68 respectively. 6/69. And the second affidavit at page 166 to 159 is signed by the learned member and marked as exhibit 10. Whereas bottom list of 2011 available at page 157 is also found to be marked as exhibit 10. Next. In the impugned opinion, the learned tribunal has discussed the evidence of only the petitioner within bracket PW1. So there is a reference to exhibit 1 to 10. Discussion. The appreciation of the exhibited documents revealed that only exhibit 1, 2, 3, 4, 6, 7, 8, 9, and 10 has been made. The other, the evidence of 2 other witnesses and discussion on exhibit 5 and 11 to 15 have not been in the said opinion. Next. Going to on discussion of the entire evidence available on the part. What provides the Indian opinion? If it's also paid, I think we 26/11 to how it will be treated. By publicity of not dealing with all the evidence on the plot. Next, accordingly, what has going to be taken to substate. He said, in our opinion, that with 6/11 to 2018, based on ask us to is the thing about the what is it said that let's go about the what is intent to remind the matter back to the said learned tribunal for a fresh opinion passed after considering all the documents available on record. As the petitioner is to be represented by a learned counsel, the petitioner is expected to appear before the said learned tribunal on within the outer limit of 307.26. And by producing a certified copy of the order, waiting for further orders to be passed by this. Next. The registration is sent back the records. Written the records. Issues that allow for the expenditure of the of the land. Or is it one loss?
My lord, deeply obliged, my lord, deeply obliged.
Oh. There were three brothers
Yes, Lord.
in the American statement.
But in one statement, this brother whose name was declared as Indian citizen lordship, he was on one occasion he stated that he is her nephew. And on the other hand, yes, contradiction of statement lordship.
Very right.
Fine. You are okay with now, the Sufi, they are not accepted. But they accepted your Sufi, then they would have those serial number of evidence and all maintained. You've done a very hard, very good work for.
But I have to look it up.
Hmm?
I have to look it again, madam.
No, you have done your job. More than that, you can't do anything. You can wake up a sleeping man. If I sleep with eyes open, you can't wake me up.
That's true, madam.
It's not necessary.
Upgraded item 35 for motion.
Lordship,
Yes, we'll proceed as per, because you have not filed the affidavit.
Lordship, in this matter, we were supposed to file an affidavit, but yesterday we filed an affidavit. Today, your Lordship, it was tagged. I took the permission of this court, your Lordship, to get the matter affidavit tagged with the petition, your Lordship.
No. No, because you see this triggered a memory. You have get the additional affidavit is that your brother was an Indian citizen, right?
Yes, your Lordship.
Inderjit Das.
Lordship.
The name of Inderjit Das was not there in your registration. That's why. I
Yes, your
confirmed.
Lordship. That's,
It's not there.
yes, your Lordship.
Because this
No.
name I did not find in your registration.
Lordship, only the name of Murari Das, she has mentioned in the written statement, and other brothers' names she has not mentioned, your Lordship. Only the thing is that
Murari Das, you don't say, you only say that the name of my
Indrajit Das.
brother appeared.
Yes, your lordship. Yes, sir. One of our brother was a serviceman that she has said in her written statement.
But Mr. M, I abstained on behalf of the petitioner. And so will be responding. Next. Having this repetition in Article 226 of the Constitution of India. This has essentially the Indian detail, page 59, 28 to 2019, passed by through in the school reference number by which the petitioner was declared to be a partner of the particular thing also. If you have the inordinate delay in selling the impugn opinion, however, keeping the issue of mental illness open. Issue notice returnable on so and so. Extra copy will into this call for the records. Of page 59, records so and so, as well as the records of page 68. It to be the opinion rendered in the case of the brother of the petitioner. You have not filed your review petition, why?
Your lordship, I had filed a review petition before the
No, where is
tribunal.
the copy? Where is the copy of the review petition?
Your lordship, that has not been annexed, your lordship, only the order has been annexed, your lordship. Because,
No, but you are risking a dismissal. Because if we don't know what is there in the review, we will not. Meantime, the prayer for bail shall be considered on receipt of the tribunal's record. In the meanwhile, if the petitioner, namely so-and-so, is apprehended, she shall not be deported out of the country without order of the court. The petitioner shall cause production of the certificate copy of the order before the Superintendent of Police border, 24 page 4. Bring the order to the notice of the second article. maybe mention that though in the restriction on order of review has been sort of review petition has been annexed, or the review petition itself is not.
Hello.
For motion, item 6.
May I please your lordship? The matter may be possible for time being.
For time being.
Time being.
Item 7.
Let the matter come after vacation, my lord. Now I have some personal grounds.
How is your health now? How is your health now?
My lord,
How is your health now?
ground. Now, okay, my lord. Now I am taking treatments from Gauhati Tata Institute in the state of Hyderabad.
Mr. A.C. Sarkar will respond for the petitioner and so also for the respondents. Pursuant to the other past year, the records of the travel will receipt which requires examination. For you to notice. Returnable on. P8 2026. Without requiring any steps to be taken. This is the matter in the admission column on P8 2026. And then we need to dispose of the matter. P8 for disposal.
Item 8.
Lordship may pass over the matter for the day as Mr. Sikdar has to leave due to some personal difficulties. He's here, Lordship. This is the-
I let the matter be taken up further in the second order.
Just one.
Six. ZH. ZH Bora. ZH Bora.
Jubair Hussain Bora.
আপনি তোকে ফোন নামটা বিচারিছে সত্য করলে হবে না।
My lord. Development.
Item 9.
May I please, your lordship. In this case, my lord, my name is not there. May I allow to argue that case? Yes, my lord. The impugn order is at page, my lord. 36 annexes 6, my lord. Here the petitioner, my lord, he was born sometime in the year, my lord, 1984, my lord. 1983, my lord. Father's name is, my lord, Annexure 20, page 22, my lord, annexure 3. My name is at serial number 461. My mother's name is at serial number 456. First one, madam. Amina Khatun.
But your father's name was different earlier, Hassan Ali.
No, Hassan Ali is my paternal uncle.
But see, page number 18
Yes, my
or
lord.
19.
She is my lord Amina, and my mother's name is Amena.
Amena.
Yes.
Acha.
Amina is my aunt. Prohibition has into enough for
ये तो दिखाया बंदे सामने ना कभी दिखना है आउट है ये सामने ना कभी नहीं जा others brothers right Hassan Ali's father's brother hmm? ये तो सर्टिफाइड कॉपी है ये हम्म हम्म They're not produced the origin.
Opinion.
This will get last line. Before that, 2 or 3 lines before that,
Yes.
the name, house number, relationship manager, relevant entities in voting system, in the original electoral roll. For examining the obstacle, it should be certified copy of the voter list.
Yes.
Which we has not published in the concerned electoral roll. It is the truth of contents of the document. This is perhaps wrong. You have appreciating the.
Yes, my lord, this is in fact, my lord. This is happens, my lord, because there is some judgment of this noble code.
No, we have got this, what is this?
Yes.
Us. The judgment which has been referred here, Nasiruddin.
Yes.
We have got copy. Page 21. Those were not certified copy, it was extract of electoral roll.
This is, here it is not certified.
But this is wrongly given in the order opinion. The travel has.
No, my lord, ignoring. No, my lord. My submission is, my lord, even though we ignore this part, my lord, this, for this reason, the 1971,
Otherwise, there is nothing in this case.
yes,
But still, you see, when there is when the evidence itself is not, let's say, appreciated. You go back and come with the same result. But certainly, we are not examining the document to say whether it is correct or wrong.
yes. No, my, that's what, my lord, my submission is, if we accept that 1971 is accepted, my lord, this observation is wrong, and therefore, if 1971 can be accepted as a valid piece of evidence, then whether the petitioner could link himself to this others.
I should be that.
No, that is the, my lord, probably, my lord, that,
If in one case we do it, we are looking at it on the basis. Basically, all of us will be same percent.
my lord, this is,
Because my lord, if your lordship may kindly see, though this observation is there, in the next para, my lord, with regard to para 6 and 7, exhibit 6 and 7, he has said that, the presence of Maqbul Hussain is not doubted, my lord. Maqbul Hussain's presence is accepted by the tribunal, even though this observation is there. Because in next para, my lord, page 39 in the opinion, it is said that exhibit 6, last part, second piece, second para, and last part, no, exhibit 6 and 7 are not.
Seven, if it was.
Yes, trust me. Maqbul Hussain documents to establish that Proceedi is the son of Maqbul Hussain. That has to establish. He could not establish that Proceedi is the son of Maqbul Hussain and resident of so and so. The Proceedi has not examined Gauhati and so and so. That is, so the tribunal has not doubted the presence of Maqbul Hussain. This 71 is my lord. Exhibit 1 is with regard to Maqbul Hussain only. So Maqbul Hussain's presence is not doubted, even though this observation is there. Now, my lord, the sole question here is whether the petitioner could establish to that Maqbul Hussain or not. We are not doubting this because that observation is definitely there. That should not have been there, my lord, because there are some misunderstood, probably misread of the judgment. Yes. No, that is your lordship has clarified in some other cases also, probably. In this same point, your lordship has clarified in some other judgment also, in some other judgment. Now, my lord, suppose we accept this document to be a valid document, the 1971 exhibit 1. We accept that, my lord, we accept that 71 voter list is a valid voter list, and Maqbul Hussain is a valid, citizen of India. So we are not doubting. Now, only to link the petitioner to that person. If he is, my lord, he could have linked himself, my lord, then there is no case. My submission. There will be probably the tribunal, my lord, we have no case. So only that may be examined if, my lord, he could establish that, and my lord, the
He has tried to establish it through his mother.
Yes.
By 2000 referring to.
This comes, then his mother comes in.
Yes.
To the mother, it can be linked.
Yes.
2005, Amina Khatun's name.
Mother is there.
And
And-
husband Maqbul Hussain.
Amina Khatun, 1971. Amina Khatun.
No, 71 list is not there.
My lord, I may go through the record for time now.
71, she was not there.
71, neither mother is not there. So whether the thereafter, my lord, mother and the father is same in the same voter list. That may be seen.
And there is a discrepancy of father's name also.
Yes, that is the only point.
Maqbul and Maqbul.
So if the mother was there and he in prior 1971, and if she could prove that she is the mother, then
That is not there, link is not there.
link is that must have been. Otherwise, my my my.
Because, my lord, that Gauhati certificate is also not proved, my lord, and there is an emblem, my lord. 16 এখন দিছি। এখানতে আছে, বুঝলাম, এখানতে আছে, কিন্তু সিঙ্গল ম্যান ভোটার লিস্ট ওখানতে আছে, গোয়ানতে আছে। যতক্ষণ আইটাকার নামটো আছে, কিন্তু আইটাকার নামটো WS লিখা নাই। কিন্তু 70 মানৰ যিখন ভোটাৰ লিষ্টত মাকৰ নাম আছে, কিন্তু এখন চিংগল মান ভোটাৰ লিষ্ট দিয়ে ন। এইখিনি কি? Sorry. My lord, one thing is that, my lord, the house number and the village name is same, my lord. Maybe regard to the voter list of 1966 and 71.
The brothers had stayed together.
Yes.
Hassan.
66, 71 is sure. 66, 71, 70. Sixty-six, 71, we have no doubt, my lord, some persons, Maqbul Hussain, this Hassan Ali, they were there in prior to 1966, and during 66, 71. Only, my lord, now, my lord, the projected mother, whose name is along with the petitioner in 2005, she is not there, my lord, prior to 71. Had her name been there in this voter list, along with these groups of persons, my lord, that would have been a better evidence. Otherwise, my lord, her presence prior to 1971 is not there.
Prior to 2005.
Prior to 2005, in fact. So this 2005 voter list is the first voter list where the projected mother along with the petitioner is there. Both of them are there only from 2005.
Mother could not have been there because in 2005 her age is shown as 52.
Yes. No, that's why.
So she becomes eligible to vote in 674
21, if it is 21.
if it is 21.
No, my lord, second aspect, when did father die? That is not
details
explained
are
in the
not there.
WS. Neither in the WS nor in the evidence. That's why, my lord, this is very important. When did father die? If father died prior to 74, then definitely, my lord, mother and father could not be in the same voter list. But if father died thereafter, the father and mother should have been there in this common voter list. That's why, my lord, when did father and mother die? In cases, it is very necessary, very important to be pleaded in the WS. So in WS, he has not even pleaded the name of the mother also. He has not given who is mother. I'm not saying about any siblings are there or not. He has not given the mother name also. Even he has not said he has a voter list along with his mother in 2005 in WS. Nothing is pleaded in WS. And though he has mentioned there's his father, son of so-and-so is there, but he has not mentioned his grandfather is so-and-so. Specifically, he has not mentioned. I'm not saying about grandmother. So nothing is there in WS. No pleading set. And evidence, he has brought this. Evidence he has first time said his mother's name. Giving evidence, he has said his mother's name is so-and-so. And then he said in 2005, me and my mother is a voter in 2005 voter. He has not mentioned anything about why the mother was not there prior to 2005 in any voter list, along with any of the family members. Had this 2005 voter list contained the name of any person from 1966-71, that that we could accept it. They are the same from the same family. Otherwise, we cannot money. Yes. 66 is one of the uncle's family, and 71 is the petitioner's brother. Even then, my lord, if we could accept that they are from the same house, because 60, my lord is saying, my lord, 66 and 70 in the same house. House number is same. So even though they were same house, had there been any one of these, my lord, 66 and 71 were enlisted in along with the present group of people in 2005 or prior to this, then that could have been the link. Otherwise, we cannot presume that this 2005 document is the link document.
because this is only in 2005, this is March after 1971. And other documents, my lord, this is settled position, this epic and this, my lord, the pen codes, this has been discussed by the tribunal properly, so there is no issue. And the other voter, Gauhati certificates, those are not true. In fact, my submission is, my lord, in case of, my lord, male persons, the Gaon Panchayat certificate and Gauhati certificate are not accepted generally. The Supreme Court in that case, my lord, said for the married woman who want to show that she got married and transferred from one place to another, only for those purpose the GP certificates were allowed, my lord. Other, those were only for those purpose, not for the male. So, in that aspect, my lord,
My lord, this voter list of 2005, my lord. This voter list was obtained, my lord, after filing of the WS, my lord. Certified copies of, my lord, 2018. That is after filing of the WS. So my humble submission is that, my lord, there is a lack of, my lord, proper guidance, my lord. When, my lord, there is lapses at there, my lord, he has not, my lord, pleaded in his WS. But obligation.
Item 10.
May it please your lordship? The petitioner in the present case, in a present matter, has expired. Therefore, lordship, we kindly be given some time to procure the death certificate of the petitioner. D.R. Ahmed, on behalf of Mr. S. Ahmed.
July.
Obliged.
Item 12.
May please, your lordship. Lordship, here I am challenging on ex parte order, lordship. Annex R1, page number 10, lordship.
Coverage is complete, you did not appear.
Yes, Lordship.
Fine. You will send it back. Here, page 14 is the application for migration. In the top, it is written, my husband is Indian. And then page 19
Migration certificate.
is the migration certificate. This Joymara Mandal is 2 years, the name is mentioned. Yes. It was not exhibited. Oh, it's not. Send it back then. If the migration is complete, we give an opportunity. But they hacking areas and the classroom to take a school. And so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has still the ex parte opinion dated 22/7/2016, page 10, passed by so and so in case number so and so, SP case number so and so, by which the petitioner was declared to be a foreigner entering in who has entered from Bangladesh on or after 25 to 1971. Next. The here for interference with the Indian opinion is opposed by the Learned Standing Council for the European Water Matters on the ground that the notice was duly served to the petitioner, but she did not appear in contest the proceedings. And the opinion has been received after about 3 years. Next one. On the perusal of the records, it appears that the mother of the petitioner made an application for migration into India. Where she had disclosed the present petitioner was then 2 years as dependent. So the application was made on 24/8/1962. And consequently, the fine. You have the record? The concerned issuing authority. You have a copy of this Annexure 3. You have a better copy of Annexure 3.
Annexure 3.
You have a better copy of this.
No, it's Annexure 3. Right.
If, 24/8/62. Question based on 24/8/62 before the Deputy High Commissioner, Dhaka, PCCA. Accordingly, the said authority had issued a migration certificate. Migration certificate dated 24/8/1962. Form 19. Hearing CR-022924. in favor of Ajay Alay Bala, A-L-A-Y, Bala, B-A-L-A, Bala, murder. The petitioner, Joy, J-O-Y, next word Mala, M-A-L-A, murder. Daughter from within 2 years as dependent. In view of this and my official certificate, what is of the constitutional opinion that petitioner deserves a chance to contest the proceedings. Accordingly, the trying to satisfy the party opinion dated 22/7/2016, page 10, past mentioned. Accordingly, the matter is remanded back for a first decision by the learned tribunal after giving a reasonable opportunity to the petitioner to the proceedings next are petitioner, who will be represented by his learned counsel. Sorry, third learned counsel shall appear before the learned member from a foreigners tribunal within brackets second bracket group from a Nogao within the outer limit of 30 outer time limit of 37/2026. Along with a certified copy of this order, have also filed a written statement of defense. Thereupon, the learned tribunal shall make an endeavor to dispose of the shall give the petitioner an opportunity to prove the documents in her support. And the state learned tribunal can make an endeavor to dispose of the proceedings in the time as prescribed under order 3 within bracket 14 of the foreigners within bracket tribunals orders from 1964 as far as it is practicable. The registry can send back the records, return back the records to the concerned tribunal. Now with the copy of the order, we will the part of the order. This sends it off in the band of the map. No order, sir.
Well, also,
Item 14.
may I please your lordship? The petitioner number 1 was expired. And petitioner number 1 was expired, and petitioner number 2 is the wife of the petitioner number 1. I have the death certificate if my lord.
Pass it on.
Right.
So fine. Here the reference is only against the husband. There's no reference against the wife. You've seen that? Very nice. Wife, obvious honor. But if upon inquiry you find against the wife, it can be re-registered. But is someone willing to substitute themselves as petitioners? Is anybody of the family interested to substitute itself as himself or herself as the petitioner in this writ petition? Do you want to impeach yourself? No.
No. No, oh. Oh, that is important. My lord, I have one judgment of this honorable court whereby this honorable court held that authorities cannot, could be at liberty to initiate press reference against the family members of a person is declared for. itu jadi itu atau 56 atau apa. Nanti one, nanti two, no problem.
No, we can only tell you, it is for you to take a decision. We are not compelling. We are not compelling you to complete yourself. It will haunt you forever. You understand the implication?
Yes.
If your father is declared to be a foreigner, can you by all means and modes prove that you are an Indian?
My lord, this honorable court recently passed an
Okay, if you don't want to understand, we are not teaching you. We are not taking up, we are not teaching you here. We can tell you it is for you to decide. Your name?
A.K. Hannan, my lord.
And Mr. A.K. Hannan, Learned Counsel, who appears on instructions of Mr. M.J. Kadir, in counsel for the petitioner of the court. Also heard. So for the respondents. Next. Find this petition. The two petitioners, namely so-and-so and so-and-so, have assailed the impugned opinion dated page 49, dated so-and-so, passed by so-and-so, in F case number so-and-so, by which the petitioner was, by which the petitioners were declared to be foreigner of post 25 from 1971 street. In this case, the petitioner number one is the husband and petitioner number two is the wife of petitioner number one. Yes, the learned counsel for the petitioner, upon instructions, has produced a copy of death certificate issued on 18/2/2021, disclosing that Veer Charan Vaishnav, VIRCHARAN had expired on 22/1/2021. Copy of death certificate, photocopy of the death certificate is retained as a part of record. Next paragraph. On the perusal of the travelers' records, it appears that the inquiry whether the suspect is a foreigner or illegal migrant or not was directed only against Veer Charan Vaishnav, son of late Gul Govinda, DUL, next to Govinda, GOVINDA, Vaishnav. And accordingly, based on the inquiry report, the Superintendent Police, within bracket B, bracket Kachar, who is the competent authority, had made reference against the said Veer Charan Vaishnav as well as the petitioner number two, Adar Moi Vaishnav, alias Adaroni Vaishnav. So accordingly, on receipt of reference from the learned member from a foreigners tribunal, court from a Kachar feature had registered the reference. Next one. On death of the petitioner number one, on 18/2/2021, the court had put a query on the learned counsel for the petitioners as to whether any family member was interested to substitute itself as the petitioner. as the opinion dated 7/2/2019, declaring Giri Charan Bhojpur to be a foreigner may be read. May have a bearing on the legal representative of the said deceased petitioner number 1. Next one. All instructions from the learned counsel for the petitioners that no member of the family is interested to circulate themselves in the matter. Next one, accordingly, on death of the met to the for the empty and bottom matter. On the 40th of the constitutional opinion that on death of B. Chairman Bachelor on 18/2/2021. No, sorry, 22/1/2021. The petition abated. Finally, attached to the said Indian opinion dated 7/2/2019, so far as petition number 1 is concerned. Next. As the the Indian opinion dated 7/2/2019, referred above. Otherwise set aside against the petition number 2 without affecting the said opinion in respect of the petition number 1. This is petition number 1. As there was no reference against there was no inquiry. Here's the petition number 2. And the reference which was forwarded to the learned member, the reference dated 28/3/2003.